Hello friends, welcome to Premier Upsc Ias. So today we are going to cover the third and most important part of the prelims, that is fundamental rights. Okay. So pertaining to fundamental rights, compulsory one question could be expected in prelims examination, sometimes directly, sometimes indirectly. So fundamental rights, Article 12 to 35. Article 12, definition of state. Article 13, laws inconsistent with or in derogation of the fundamental rights. Article 14 to 18, right to equality. Article 19 to 22, right to freedom. Article 23 to 24, right against exploitation. Article 25 to 28, right to freedom of religion. Article 29 to 30, cultural and educational rights. Article 31, right to property, which was later repealed. Article 31A to D, saving of certain laws. Article 32, right to constitutional remedies. Article 33, power of Parliament to modify the rights conferred by this part in their application to forces, etc. Article 34, restriction on rights conferred by this part while martial law is enforced in any area. Article 35, legislation to give effect to the provisions of this part. Introduction. Fundamental rights are mentioned under Part 3 of the Indian Constitution. Part 3 of the Indian Constitution is rightly described as the Magna Carta of India. The fundamental rights are meant for promoting the ideal of political democracy. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. It contains a very long and comprehensive list of justiciable fundamental rights. The fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. They are most essential for all round development, material, intellectual, and moral and spiritual of the individual. There are certain rights which are mentioned in the Constitution but not under fundamental rights. Such rights are called constitutional rights, example, right to vote, etc. There are certain rights which are made available to citizens through the passage of laws by legislatures, both center or state. Such rights are called as statutory rights, example, right to information, etc. Public and private rights. The rights which were thus selected by the Constituent Assembly can be broadly classified into two categories, public and private. But both these have the same purpose of putting an end to arbitrary rule. Public or political rights are the right to choose their rulers, the right to hold them responsible for their conduct, right to form association or cooperatives, the right to share in law making, etc. Among the private rights were the right to personal freedom, the right to privacy, the right to freedom of religious belief, the right to thought and expression, etc. Fundamental rights contains the basic principle that as a human being, every individual is entitled to enjoy certain rights, and the enjoyment of such rights does not depend upon the will of any majority or minority. The majority does not have the right to abrogate such rights. In fact, the legitimacy of the majority to rule is derived from the existence of these rights. Originally, the Constitution provided for seven fundamental rights. However, in 1978, the right to property was deleted from the list of fundamental rights. At present, the Indian Constitution has classified these rights into six categories as mentioned in the coming slide. Six fundamental rights are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. Nature of fundamental rights. Some of the fundamental rights are considered as a negative obligations on state, example Article 14, with certain exceptions, example Article 21A. Negative obligations in the sense that the state cannot do something that hurts or curtails people's rights. Majority of rights mentioned in Part 3 are positive in nature and enjoyed by citizens against the state. They are justiciable, allowing persons to move the courts for their enforcement if and when they are violated. Article 32. Fundamental rights are not absolute rights, as there are certain reasonable restrictions can be imposed upon them. Since individual rights cannot override national security and general welfare, so they are not absolute but qualified. Fundamental rights can be suspended during an emergency. Fundamental rights of people occupying sensitive positions, armed forces, intelligence agencies, etc., can be restricted or even denied by Parliament by law. Most of the rights are self-executory, that is, the Parliament not need to frame laws in order to implement these rights. However, there are certain exceptions. For example, for the implementation of right to education under Article 21A, a law was made by the Parliament. Some of them are available only to citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like corporations or companies. They are not sacrosanct or permanent. The Parliament can curtail or repeal them without hurting the basic structure by only a Constitutional Amendment Act. Their scope of operation is limited by Article 31A, 31B, and 31C. Their application can be restricted while martial law is in force in any area. Definition of state. Article 12 has defined the term state for the purposes of Part 3. According to it, the state includes the following: Government and Parliament of India, Government and Legislature of states, all local authorities, all other authorities. Thus, it is the actions of these agencies that can be challenged in the courts as violating the fundamental rights. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12. Laws inconsistent with fundamental rights. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it expressly provides for the doctrine of judicial review. Judicial review of Part 3 of the Constitution is not explicitly mentioned. It is implicitly conveyed through Article 13(1). This power has been conferred on the Supreme Court Article 32 and the High Court's Article 226. The term law in Article 13 has been given a wide connotation so as to include the following: permanent laws, temporary laws, statutory instruments in the nature of delegated legislation, non-legislative sources of law. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. If amendments to the Constitution are not covered under the term law, then the Parliament can amend the fundamental rights by amending the Constitution itself. This is the ultimate question comes in the picture. Let's understand it through the judgments given by the Supreme Court in different cases. Amendability of fundamental rights. Shankari Prasad versus Union of India, 1951 case. The Supreme Court in this case held that the Constitutional Amendment Act is not a law. Thus, Parliament has the power to amend any fundamental right by using the constitutional legislative power. Sajjan Singh versus State of Rajasthan case, 1965. It also gave a similar verdict in this case that the Parliament is fully authorized to amend the fundamental rights. Golaknath versus State of Punjab, 1967 case. However, in this case, the Supreme Court adjudged the following: fundamental rights had been given transcendental position by the Constitution, and even Parliament cannot amend fundamental rights. 24th Constitutional Amendment Act, 1971. By the 24th Amendment, Parliament amended Article 13 and Article 368. This clarified that Parliament has the power to amend fundamental rights through constitutional amendments. Kesavananda Bharati versus State of Kerala, 1979. Amending power of Parliament was challenged in the Supreme Court in this case, but the Supreme Court of India upheld the validity of 24th Constitutional Amendment Act. However, the Supreme Court held that the amending power of the Parliament is limited and is subject to basic structure of the Constitution. The term basic structure is not explicitly defined by the Supreme Court. However, in various judgments, the Supreme Court has held that the following concepts form a part of the basic structure: Some constituents of the basic structure are secular character of the Constitution, supremacy of the Constitution, federalism, separation of powers, power of judicial review, the mandate to build a welfare state, rule of law, Article 32, right to equality. Article 14, equality before law and equal protection of laws. Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Article 16. Equality of opportunity in matters of public employment. Article 17. Abolition of untouchability and prohibition of its practice. Article 18. Abolition of titles except military and academic. Equality before law and equal protection of law. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. This provision confers rights on all persons, whether citizens or foreigners. Moreover, the word person includes legal persons, that is, statutory corporations, companies, registered societies, or any other type of legal person also. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. Where equals and unequals are treated differently, Article 14 does not apply. While Article 14 forbids class legislation, it permits reasonable classification of persons, objects, and transactions by the law. But the classification should not be arbitrary, artificial, or evasive. Rather, it should be based on an intelligible differential and substantial distinction. For example, announcing welfare schemes for the BPL category, like PDS, does not amount to a violation of Article 14, as it attempts to reduce the inequality between the BPL category and the non BPL category. Positive and the negative concepts. The concept of equality before the law is of British origin, while the concept of equal protection of laws has been taken from the American Constitution. Equal protection of laws are positive concepts. The concept of equal protection of laws implies the following: the equality of treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws, the similar application of same laws to all persons who are similarly situated, and the like should be treated alike without any discrimination. Equality before law, that is negative concept. The concept of equality before law is an element of the concept of rule of law propounded by A.V. Dicey, the British jurist. This concept connotes the following: the absence of any special privileges in favor of any persons, the equal subjugation of all persons to the ordinary law of land administered by ordinary law courts, and no person is above the law, whether rich or poor, high or low, official or not official. Rule of law. The concept of rule of law concept has the following three elements or aspects: absence of arbitrary power, equality before the law, the primacy of the rights of the individual. Rule of law in Indian system. Only the first and the second element of the concept given by Dicey are applicable to the Indian system and not the third one. Absence of arbitrary power, equality before the law. In the Indian system, the constitution is the source of individual rights. The Supreme Court held that the rule of law as embodied in Article 14 is a basic feature of the constitution. Hence, it cannot be destroyed even by an amendment. Exception of equality. The rule of equality before the law is not absolute, and there are constitutional and other exceptions to it. These are mentioned below. Article 361. The President of India and the Governor of States enjoy some immunities. Article 361A. Protection of the publication of any proceedings of either House of Parliament or either House of the Legislature of a state. Article 105. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof. Article 194. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof. Article 31C. The laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that where Article 31C comes in, Article 14 goes out. The foreign sovereigns, that is, rulers, ambassadors, and diplomats, enjoy immunity from criminal and civil proceedings. The UNO and its agencies enjoy diplomatic immunity. Prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizen only on the following five grounds: religion, race, caste, gender or sex, and place of birth. Exception of non-discrimination. There are the three exceptions to this general rule of non-discrimination: any special provision for women and children, any special provision for the advancement of any socially and educationally backward classes, or for the SCs and STs, any special provision for the advancement of any socially and educationally backward classes, or for the SCs or the STs regarding their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. It was added by the 93rd Amendment Act of 2005. A law was enacted to give effect to these amendment called Central Educational Institutions Reservation in Admission Act 2006. The center provides a quota of 27% for candidates belonging to the other backward classes (OBCs) and 10% for the candidates belonging to general category (EWS) in all central higher educational institutions. Equality of opportunity in public employment. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. No citizen can be discriminated against or be ineligible for any employment or office under the state on the only eight grounds of religion, race, caste, sex, place of birth, Article 15, descent or residence. Exceptions of equality of opportunity. There are three exceptions. 1. Parliament can prescribe residence as a condition. 2. The state can provide for reservation of appointments or posts in favor of any backward class. 3. A law can provide that the incumbent of an office related to the religious or denominational institution or a member of its governing body. Abolition of untouchability. Article 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with the law. Civil Rights Act 1955 defines civil right as any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The term untouchability has not been defined either in the Constitution or in the Act. Acts of Offense of Untouchability. The Civil Rights Act 1955, preventing, justifying, denying access and insulting, refusing to admit, preaching, refusing to sell goods or render services to any such person. The Supreme Court held that the right under Article 17 is available against private individuals. It is the constitutional obligation of the state to take necessary action to ensure that this right is not violated. A person convicted of the offense of untouchability is disqualified for election to the parliament or state legislature. Abolition of titles. Article 18 abolishes titles and makes four provisions in that regard. It prohibits the state from conferring any title except military or academic distinction on anybody, whether a citizen or a foreigner. It prohibits a citizen of India from accepting any title from any foreign state. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument, or office from or under any foreign state without the consent of the president. In 1996, the Supreme Court upheld the constitutional validity of the national awards Bharat Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri. It ruled that these awards do not amount to titles within the meaning of Article 18 that prohibits only hereditary titles of nobility. Therefore, they are not violative of Article 18 as the theory of equality does not mandate that merit should not be recognized. Right to freedom. Article 19. Protection of six rights regarding freedom of speech and expression, assembly, association, movement, residence, and profession. Article 20. Protection in respect of conviction for offences. 21. Protection of life and personal liberty. 21A. Right to elementary education. Article 22. Protection against arrest and detention in certain cases. Protection of six rights. Article 19 guarantees to all citizens the six rights. These are right to freedom of speech and expression, right to assemble peaceably and without arms, right to form associations or unions or cooperative societies, right to move freely throughout the territory of India, right to reside and settle in any part of the territory of India, right to practice any profession or to carry on any occupation, trade, or business. Originally, Article 19 contained seven rights, but the right to acquire, hold, and dispose of the property was deleted by the 44th Amendment of 1978. Originally, Article 19 contained seven rights, but the right to acquire, hold, and dispose of the property was deleted by the 44th Amendment Act of 1978. Now, the right to property is only a constitutional right under Article 300A. These six rights are protected against only state action and not private individuals. Moreover, these rights are available only to the citizens and to shareholders of a company, but not to foreigners or legal persons like companies or corporations, etc. The state can impose reasonable restrictions on the enjoyment of these six rights only on the grounds mentioned in Article 19 itself and not on any other grounds. Freedom of speech and expression. The Supreme Court held that the freedom of speech and expression includes the following: right to propagate one's views, freedom of silence, freedom of the press, freedom of commercial advertisements, right against tapping of telephonic conversation, right to telecast, that is, the government has no monopoly on electronic media, right to know about government activities, right against ban called by a political party or organization, right against the imposition of free censorship on a newspaper, right to demonstration or picketing, but not right to strike. Reasonable restriction, freedom of speech and expression. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression in the following grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Freedom of assembly. Every citizen has the right to assemble peaceably and without arms. It includes the right to hold public meetings, demonstrations, and take out processions. This freedom can be exercised only on public land, and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, riotous assemblies or one that causes a breach of public peace or one that involves arms. This right does not include the right to strike. Reasonable restriction, freedom of assembly. The state can impose reasonable restrictions on the exercise of the right of assembly on the following two grounds, namely sovereignty and integrity of India and public order, including the maintenance of traffic in the area. Consent. Above said restriction can be implemented by the legal procedure under the following two sections. Section 144 of Criminal Procedure Code and Section 141 of IPC, Indian Penal Code. Section 144 of Criminal Procedure Code. Under Section 144 of The Criminal Procedure Code 1973, a magistrate can restrain an assembly, meeting, or procession if there is a risk of any of the following: obstruction, annoyance, or danger to human life, health, or safety, or disturbance of the public tranquility, or a riot or in any affray. Section 141 IPC. Under Section 141 of the Indian Penal Code, as the assembly of five or more persons becomes unlawful if the object is one of the following: to resist the execution, to forcibly occupy the property, to commit any mischief, to force some person to do an illegal act, and to threaten the government or its officials on exercising lawful powers. Freedom of association. It includes the right to form the following type of groupings, associations: one, political parties, companies, partnership firms, societies, clubs, organizations, trade unions, or anybody of persons like trust, NGOs, etc. It not only includes the right to start an association or union, but also to continue with the association or union as such. However, the right to obtain recognition of the association is not a fundamental right. Further, it covers the negative right to of not to form or join an association or union. Reasonable restrictions. The state can be imposed restrictions on the exercise of this right on the following grounds of sovereignty and integrity of India, public order and morality. Freedom of movement. This freedom entitles every citizen to move freely throughout the territory of the country. This right underlines the idea that India is one of unit so far as the citizens are concerned. Thus, the purpose is to promote national feeling and not parochialism. The freedom of movement has two dimensions, internal and external. Article 19 protects only the first dimension, that is, right to move inside the country. The second dimension is dealt with Article 21. Reasonable restriction, freedom of movement. The grounds of imposing reasonable restrictions on this freedom of are two, namely the interest of the general public and the protection of interest of any scheduled tribe. The Supreme Court held that the freedom of movement of prostitutes can be restricted on the ground of public health and in the interest of public morals. The Bombay High Court validated that the restrictions on the movement of persons affected by AIDS. Freedom of residence. This right has the following two parts: the right to reside in any part of the country, which means no stay at any place temporarily, and the right to settle in any part of the country, which means to set up a home or domicile at any place permanently. This right is intended to remove internal barriers within the country or between any of its parts. This promotes nationalism and avoids narrow mindedness. Reasonable restriction, freedom of residence. The state can impose reasonable restrictions on the exercise of this right on two grounds, namely the interest of the general public and the protection of interest of any scheduled tribes. The Supreme Court held that certain areas can be banned for certain kinds of persons like prostitutes and habitual offenders. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. Both are complementary to each other. Freedom of profession or occupation. Freedom of profession or occupation. All citizens are given the right to practice any profession or to carry on any occupation, trade, or business. However, the state is empowered to prescribe professional or technical qualifications necessary, carry on by itself any trade, business, industry, or service. Thus, the state is not required to justify its monopoly. Reasonable restriction, freedom of profession or occupation or trade. The state can impose reasonable restriction on the exercise of this right in the interest of general public. This right does not include the right to carry on a profession or business or trade or occupation that is immoral or dangerous. The state can absolutely prohibit these or regulate them through licensing. Protection in respect of conviction for offences. Article 20 grants protection against arbitrary and excessive punishment to an accused person. It protects all persons, whether citizen or foreigner, or the legal person like a company or a corporation. It contains three provisions in that direction, such as no ex post facto law, no double jeopardy, no self incrimination. Ex post facto law. An ex post facto law is one that imposes penalties retroactively, that is, upon acts already done or which increases the penalties for such acts. The enactment of such a law is prohibited by the first provision of Article 20. Accordingly, no person shall be convicted of any offence except for a violation of a law in force at the time of the commission of the act, nor subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. However, this limitation is imposed only on criminal laws, not on civil laws or tax laws. In other words, civil liability or a tax can be imposed retrospectively. Finally, the protection or immunity under this provision cannot be claimed in case of preventive detention or demanding security from a person. The protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. Self-incrimination. The protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to compulsory production of material objects. Compulsion to give thumb impression, specimen signature, blood specimens, and compulsory exhibition of the body. Further, it extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. Protection of life and personal liberty. Article 21 declares that no person shall be deprived of his life or personal liberty except according to the procedure established by law. This right is available to both citizens and non-citizens. In the famous Gopalan case 1950, the Supreme Court has taken a narrow interpretation of Article 21. But in Menaka case 1978, the Supreme Court overruled its judgment in the Gopalan case by taking a wider interpretation of Article 21. Therefore, it ruled that the right to life and personal liberty of a person can be deprived by the law, provided the procedure prescribed by that law is reasonable, fair, and just. In other words, it has introduced the American expression due process of law. In effect, the protection under Article 21 should be available not only against arbitrary execution action, but also against the arbitrary legislative action. Further, the court held that the right to life, as embodied in Article 21, is not merely confined to animal existence or survival, but it includes within its ambit the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete, and worth living. It has declared that the following rights as part of Article 21: right to live with human dignity against bonded labor, right of women to be treated with decency and dignity, right to decent environment including pollution-free water, air, and protection against hazardous industries, freedom from noise pollution, right to livelihood, privacy, shelter, health, sleep, electricity, appropriate life insurance policy, travel abroad, right to free education up to 14 years of age, right to free legal aid against solitary confinement, speedy trial against handcuffing, against inhuman treatment, delayed execution against custodial harassment, right to emergency medical aid, timely medical treatment in government hospital, right not to be driven out of state, right to fair trial, prisoner to have necessities of life, right against public hanging, appeal from a judgment of conviction against bar fetters, right to hearing, to information, to reputation, right to social security and protection of the family, right to social and economic justice and empowerment. Due process of law, American Constitution. The words due process suggest a concern with procedure rather than substance. Due process involves both procedural and substantive aspects. Procedural due process requires fairness in the methods used to deprive a person of life, liberty, or property, while substantive due process requires valid governmental justification for taking a person's life, liberty, or property. Due process generally requires fairness in government proceedings. Laws should be applied to persons equally without discrimination on prohibited grounds such as gender, nationality, age, etc. For example, when a person's home is in danger of tax foreclosure, the notice of delinquency is required to be sent within a certain time period, and the person must be allowed to pay the full amount owed before it is sold to a third party. If there is an error in taxation or the person wishes to contest the appraisal, an appeals process is available. Procedure established by law, Indian Constitution. The expression procedure established by law in the context of deprivation of life and liberty under Article 21 was interpreted in the Manika Gandhi versus Union of India case of 1978. As limited to the procedure, the judges were agreed that the procedure must be reasonable and fair and not arbitrary or capricious. For if the procedures were arbitrary, it would violate Article 14, since Article 14 is not consistent with any arbitrary power. Right to education. Article 21A declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. This provision was added by the 86th Constitutional Amendment Act of 2002. Even before this amendment, the Constitution contained a provision for free and compulsory education for children under Article 45 in part of the Directory Principles of State Policy. In 1993 itself, the Supreme Court recognized a fundamental right to primary education in the right to life under Article 21. 86th Constitutional Amendment Act of 2002. This amendment changed the subject matter of Article 45 in Directive Principles. It now reads, the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. It also added a new fundamental duty under Article 51A. It reads, it shall be the duty of every citizen of India to provide opportunities for education to his child or ward between the age of 6 and 14 years. In pursuance of Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education, Right to Education Act 2009. Protection against the arrest and detention. Article 22 grants protection to persons who are arrested or detained. The Article 22 has two parts. The first part deals with the cases of ordinary law, and the second part deals with the cases of preventive detention law. The first part of Article 22 confers the following rights on a person who is arrested or detained under an ordinary law: right to be informed of the grounds of arrest, right to consult and to be defended and by a legal practitioner, right to be produced before a magistrate within 24 hours, excluding the journey time, right to be released after 24 hours unless the magistrate authorizes further detention. These safeguards are not available to an enemy alien or a person arrested or detained under a preventive detention law. They apply only to an act of a criminal or quasi-criminal nature or some activity prejudicial to the public interest. The second part of Article 22 grants protection to persons who are arrested or detained under a preventive detention law. This protection is available to both citizens as well as aliens and include the following. The detention of a person cannot exceed 3 months unless an advisory board consists of judges of a high court reports sufficient cause for extended detention. The grounds of detention should be communicated to the detainee. However, the facts considered to be against the public interest need to be disclosed. The detainee should be afforded an opportunity to make a representation against the detention order. Powers of Parliament under Article 22. Article 22 also authorizes the Parliament to prescribe the following. Mm, to the circumstances and the classes of cases in which a person can be detained for more than 3 months under a preventive detention law without obtaining the opinion of an advisory board. The maximum period for which a person can be detained in any classes of cases under a preventive detention law, and the procedure to be followed by an advisory board in an inquiry. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislatures. The Parliament has exclusive authority to make a law of preventive detention for reasons connected with the following: defense, foreign affairs, and security of India. Both the Parliament as well as the state legislatures can concurrently make a law of preventive detention for the following reasons connected with the security of a state, maintenance of public order, and maintenance of supplies and services essential to the community. Preventive detention. Detention of is of two types, namely punitive and preventive. Punitive detention is to punish a person for an offense committed by him after trial and conviction in a court. Preventive detention, on the other hand, means detention of a person without trial and a conviction by a court. Its purpose is not to punish a person for a past offense, but to prevent him from committing an offense in the near future. Thus, preventive detention is only a precautionary measure and based on suspicion. Right against exploitation. Article 23. Prohibition of traffic in human beings and forced labor. Article 24. Prohibition of employment of children in factories, etc. Prohibition of traffic in human beings and forced labor. Article 23 prohibits traffic in human beings, beggar, forced labor, and other similar forms of forced labor. Any contravention of this provision shall be an offence punishable in accordance with the law. This right is available to both citizens and non-citizens. It protects the individual not only against the state but also against private persons. The expression traffic in human beings include selling and buying of men, women, and children like goods, immoral traffic in women and children, including prostitution, devadasis, and slavery. To punish these acts, the Parliament has made the Immoral Traffic Prevention Act 1956. The word force includes not only physical or legal force, but also force arising from the compulsion of economic circumstances, that is, working for less than the minimum wage. Exception of Article 23. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purposes for which it is not bound to pay, for example, military service or social service. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste, or class. Prohibition of employment of children in factories, etc. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway, but it does not prohibit their employment in any harmless or innocent work. The Child Labor Prohibition and Regulation Act 1986 is the most important law in this direction. Child Labor Prohibition and Regulation Amendment Act 2016. The Amendment Act 2016 amended the Child Labor Prohibition and Regulation Act 1986. It has renamed the Principal Act as the Child and Adolescent Labor Prohibition and Regulation Act 1986. The Amendment Act prohibits the employment of children below 14 years in all occupations and processes. Further, the Amendment Act prohibits the employment of adolescents 14 to 18 years of age in certain hazardous occupations and processes. Right to freedom of religion. Article 25. Freedom of conscience and freedom of profession, practice, and propagation of religion. Article 26. Freedom to manage religious affairs. Article 27. Freedom from payment of taxes for promotion of any religion. Article 28. Freedom from attending religious instruction or worship in certain educational institutions. Article 29. Protection of language, script, and culture of minorities. Article 30. Right of minorities to establish and administer educational institutions. Right to property repealed. Originally, the right to property was one of the seven fundamental rights under Part 3 of the Constitution. It was dealt by Article 19(1)(f) and Article 31. Article 19(1)(f) guaranteed to every citizen the right to acquire, hold, and dispose of property. Article 31, on the other hand, guaranteed to every person, whether citizen or non-citizen, right against deprivation of his property. 44th Amendment Act 1978. But the 44th Amendment Act 1978 abolished the right to property as a fundamental right by repealing the Article 9(1)(f) and Article 31 from the Part 3. Instead, the Act inserted a new Article 300A in Part 12 under the heading Right to Property. It provides that no person shall be deprived of his property except by authority of law. Thus, the right to property still remains a legal right or a constitutional right, though no longer a fundamental right. It is not a part of the basic structure of the Constitution. Right to property as a legal right. The right to property as a legal right is distinct from the fundamental rights and has the following implications. It can be regulated, curtailed, abridged, or modified by an ordinary law of the Parliament. It protects private property against executive action but not against legislative action. In case of violation, the aggrieved person cannot directly move the Supreme Court under 32 for its enforcement. He can move to the High Court under Article 226. No guaranteed right to compensation in case of acquisition or requisition of the private property by the state. Right to compensation under Part 3. Though the fundamental right to property under Part 3 has been abolished, the Part 3 still carries two provisions which provide for the guaranteed right to compensation in any case of acquisition or requisition of the private property by the state. These two cases where the compensation has to be paid are when the state acquired the property of a minority educational institution, Article 30, and when the state acquired the land held by a person under his personal cultivation and the land is within the statutory ceding limits, Article 31A. Exception to the fundamental rights. 31A. Saving of laws providing for acquisition of estates. 31B. Validation of certain acts and regulations. Article 31C. Saving of laws giving effect to certain directive principles. Right to constitutional remedies. Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. In other words, the right to get the fundamental rights protected is itself a fundamental right. Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be a nullity. It is the very soul of the Constitution and the very heart of it. The Supreme Court has ruled that Article 32 is the basic feature of the Constitution. Article 32 contains the following four provisions. 1. The right to move to the Supreme Court. 2. The Supreme Court shall have the power to issue directions or orders or writs. 3. Parliament can empower any other act, but it does not include high courts because Article 226 has already conferred. 4. The right to move the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. Only the fundamental rights guaranteed by the Constitution can be enforced under Article 32, and not any other right like non-fundamental constitutional rights, statutory rights, customary rights, and so on. In other words, the Supreme Court under the Article 32 cannot determine a question that does not involve fundamental rights. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or the legislation unless it directly infringes any of the fundamental rights. Power of the Supreme Court under Article 32. By virtue of this article, the Supreme Court has been constituted as the defender and the guarantor of the fundamental rights of the citizens. It has been vested with the original and wide powers for that purpose. Original because an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Wide because its powers is not restricted to issuing of orders or directions, but also writs of all kinds. In case of the enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not an exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. It vests original powers in the High Court to issue directions, orders, and writs of all kinds for the enforcement of the fundamental rights. It means when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Writ jurisdiction of the Supreme Court. The writ jurisdiction of the Supreme Court differs from that of the High Court in three respects. 1. The writ jurisdiction of the Supreme Court is narrower than that of the High Court, since any High Court can issue writs not only for the enforcement of the fundamental rights, but also for any other purpose. 2. The territorial jurisdiction of the Supreme Court for the purpose of issuing writs is wider than that of a High Court. The Supreme Court can issue writs against a person or government throughout the territory of India. A remedy under Article 32 is in itself a fundamental right, and hence the Supreme Court may not refuse to exercise its writ jurisdiction. On the other hand, a remedy under Article 226 is discretionary and hence a High Court may refuse to exercise its jurisdiction, rights, types, and scope. The Supreme Court under Article 32 and the High Courts under Article 226 can issue the following writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Habeas corpus, to have the body of. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the detention is lawful. The proceeding is for contempt of a legislature or a court. Detention is by a competent court and detention is outside the jurisdiction of the court. Mandamus, fee command. It directs activity. It is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. The writ of mandamus cannot be issued against a private individual or body to enforce departmental instruction that does not possess statutory force when the duty is discretionary and not mandatory to enforce a contractual obligation against the President of India or the state governors and against the Chief Justice of a High Court acting in a judicial capacity. Prohibition. To forbid. The prohibition directs inactivity and is only preventive. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari, to be certified or to be informed. The certiorari is both preventive as well as curative. Quo warranto, by what authority or warrant? It is issued by the court to inquire into the legality of the claim. Armed Forces and Fundamental Rights. Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. The objective of this provision is to ensure the proper discharge of their duties and the maintenance of discipline among them. The power to make laws under Article 33 is conferred only on Parliament and not on state legislatures. Any such law made by Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Accordingly, the Parliament has enacted the Army Act 1950, the Navy Act 1950, the Air Force Act 1950, the Police Forces Restriction of Rights Act 1966, the Border Security Force Act, and so on. Martial law and fundamental rights. Article 34 provides for the restrictions on fundamental rights while martial law is enforced in any area within the territory of India. It empowers the Parliament to indemnify any government servant or any other person for any acts done by him in connection with the maintenance or restoration of order in any area where martial law was in force. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. What is martial law? The concept of martial law has been borrowed in India from the English common law. However, the expression martial law has now been defined anywhere in the Constitution. Has not been defined. Literally, it means military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations framed outside the ordinary law. It does imply the suspension of ordinary law and the government by military tribunals. It is different from the military law that is applicable to the armed forces. The martial law is imposed under the extraordinary circumstances. Its justification is to repel force by force for maintaining or restoring order in the society. The parliament can validate any sentence passed, punishment inflicted, forfeiture ordered, or the other act done under the martial law in such area. The declaration of a martial law under Article 34 is different from that the declaration of a national emergency under the Article 352. Difference between the martial law Article 34 and national emergency Article 352. It affects only fundamental rights. But in the martial law, but in national emergency, it affects not only fundamental rights but also center-state relations, distribution of revenues, the legislative powers between center and states, and may extend the tenure of the parliament. Martial law, it suspends the government and ordinary law courts. National emergency, it continues the government and ordinary law courts. Martial law, it is imposed to restore the breakdown of law and order due to any reason. National emergency, it can be imposed only on three grounds: war, external aggression, or armed rebellion. Constitutional rights only for citizens. The Constitution confers the fundamental following rights and privileges on the citizens of India and denies the same to aliens. Article 15, 16, 19, 29, and 30. Right to vote, right to contest, eligibility to hold certain public offices. Difference between the fundamental rights and directive principles of state policy. Fundamental rights justiciable, DPSP non-justiciable. Fundamental rights political justice, DPSP for economic and social justice. Fundamental rights have legal sanction, DPSP have no legal sanction. Fundamental rights personal and individualistic, automatically enforced. Courts declares a law violating a fundamental right as unconstitutional, whereas DPSP, societarian and socialistic, not automatically enforced. Courts can't declare a law violating DPSP as unconstitutional.